Okay, welcome everyone. Let's get started so we don't waste too much more time. Welcome back to the Valley Columbia Center on Sustainable International Investment Speaker Series, sponsored again wonderfully by Curtis Millay and by Crowell and Mooring, and by the center here at Columbia, the Center on International Commercial and Investment Arbitration. So I will turn it over to Ian to introduce our speaker.
Well, thanks very much, Lisa. Once again, it's a pleasure to be here for the spring speaker series. We've had a great variety of speakers this year, and promises to be even more exciting as we go on over the next 2 months. But today we have the honor of having Stuart Newberger, who's a senior partner at Crowell and Mooring, and Stu's had a very interesting and long career as a litigator, but also in the international arbitration field. But one of the most interesting parts of his international background is his experience in international terrorism cases. Stu received a lot of his experiences working with and against governments in the U.S. courts, seeking reparations, seeking compensation for victims of terrorism. And you know, there are a number of cases he's worked on. I think our firm has worked on over a dozen of those cases and tried them and taken them through the U.S. courts. Some of the more well-known ones, I guess, is the UTA Flight 772 case against Libya, which resulted in a $1.7 billion judgment for the victims in that case, as well as a number of cases against Iran, including the Terry Anderson case and the Beirut U.S. Embassy bombing. So this is the sort of background Stu has come from in his international experience, and more recently he's been very involved in investor-state arbitration. So we asked him to come and provide the benefit of his experience and give us an expression, an impression of his recent experiences and his views. So without getting into much more detail, I'd just invite Stu to regale us and to give us his views. So thank you very much, Stu.
Thank you, Ian. In other words, can you just tell some war stories? Which is, a typical U.S. trial lawyer way to entertain people. Usually we have alcohol, not pizza. So I'll try and compensate, although it's a difficult climb. And thank you very much for coming. It's an honor to be here and see you all. I know it's a mixed crowd of people who have a lot of very different backgrounds, both U.S. and overseas legal backgrounds, academic backgrounds, and so I'll try and give these comments in a way that everyone can at least get a little bit out of it. As Ian mentioned, I came to this world of practice where I'd say maybe about 80% of my current docket in the last several years is in the investor-state dispute world. And I've actually tried a number of very large cases. But I came at it because when I was younger, I used to be younger, believe it or not, and I was an assistant U.S. attorney in Washington, I represented a lot of U.S. government agencies on what were basically international disputes that wound up in the federal courts in Washington, both in the U.S. District Court and the D.C. Circuit, and even a few that went to the Supreme Court. So my first introduction, if you will, to international dispute work was representing the U.S. government when it was the defendant, as we call it in court, on all kinds of things relating to President Reagan's policies in Central America during the 80s, some issues involving Europe, and that's where I got my first taste of these sorts of things. When I joined Crowell and Mooring, which is about 25 years ago, hard to believe, I was a traditional trial appellate lawyer, working on a lot of things, and I started just by happenstance. I didn't set out to build a practice like this, but I started getting cases almost right away when Congress enacted the terrorism amendments to the Foreign Sovereign Immunities Act. And so I started representing people against Iran and Libya for things like hostage taking in Lebanon and blowing up embassies and blowing up jetliners over North Africa on their way to Paris. And that further got me involved in more, and I call it an extension, if you will, of international dispute work, very heart-wrenching work. And from that I got, again, didn't plan it, started having clients call up who had international commercial disputes. So I started trying cases at the ICC in Paris, the Austrian Federal Economic Chamber in Vienna, and London Court of International Arbitration, and that sort of thing. And then from that, I started getting calls for disputes that were not commercial, but actually were with sovereigns. And the only potential solutions were to see if there were treaties, whether bilateral investment treaties, which you're familiar with, or multilateral investment treaties, like the Energy Charter Treaty. And so for the last, I'd say 9 or 10 years, I've probably devoted most of my time to litigating the investor-state cases at various venues, which I'll talk about in a minute, and still try some international commercial arbitration cases. Birgit, my colleague here, and I had a big one at the ICDR just a couple of months ago right downtown for an Italian client, so we still do some of those. But my focus of my practice is mostly disputes with governments. I've also represented governments, by the way. We actually are currently representing the Central Bank of Colombia in a case in the Southern District. I've represented the Hashemite Kingdom of Jordan on some foreign sovereign issues down in the Fifth Circuit. So I'm not just someone who only sues governments. I have, and under the right circumstances, would continue to represent a government, even in an investor-state dispute. But mostly my comments today are going to focus on my experience representing claimants against sovereigns in these international disputes, most of which arise under treaties and public international law. And that's the intro, if you will, for what the talk is about and my background. When the Valley Center asked me through Ian to think of a theme, I had to scratch my head a little bit. I did not want this to be a purely academic exercise. You can read cases, you can read treaties. You don't need me. You have much smarter people who've written all kinds of books and law review articles on that. I'm going to give you more of the trial lawyers. War stories might be an exaggeration, but they're examples of cases I've worked on that I think fit the theme. What is the theme? Well, in short, how do you get the sovereign government's attention? And then what do you do once you get their attention? What happens when you get the tiger by the tail? Well, most dangerous thing is to let go. That's usually the first thing people tell you is don't let go. And that's kind of true here. And so in the kind of cases that I've dealt with, which have arisen in Eastern Europe from the former Soviet Union, from the former Soviet republics, mostly in Central Asia, Kazakhstan, someone we've litigated against in a Kazakhstan case, his firm is here, Uzbekistan, several big cases against Turkey, which I'm going to talk about. That probably has taken most of my time. The Prime Minister of Turkey is not a big fan of mine. I'm actually persona non grata in Turkey right now, which is too bad because it's a lovely country. But I'm really not in the mood for a one-way ticket to a trip to Turkey right now, although I've been there many times. And other countries that we have counseled clients on. So let's get right to it. And some of this I know you've heard before, but I want to give it sort of a context. How do you get a sovereign's attention? What do you do when you have it? Well, the first thing when a potential client calls you up, and I get most of these cases out of the blue, it's usually a weird email from some local lawyer somewhere, is we have this dispute. Do you think we can get into an international venue? We'll translate that. Can we get it out of the domestic courts? Or can we get it out of a commercial dispute context, even under an international commercial arbitration clause, which we're familiar with? And the answer, of course, always turns on, is there a treaty that might potentially apply? And if there is, can you meet the three-part test? Is there jurisdiction? How strong is your case on the merits? And what kind of damages case do you have? And we've dealt with all of these. In some of our cases, jurisdiction, as often happens in the treaty world, jurisdiction is probably the dispositive issue in 70 to 80% of the cases. And that's the tough nut to crack. And tribunals, even sympathetic tribunals, tend to take a hard look at jurisdiction before they do anything else. And that's something that you have to bear in mind, even if there's a treaty. You can't take it for granted. On the merits, in some ways, merits may be the easiest of the three elements, because if you have a strong case on jurisdiction, usually it's because the country did something really bad. violated their own laws in a way that might implicate provisions of a treaty, fair and equitable treatment, discriminatory treatment, expropriation, although that's less common. Countries aren't that stupid usually. They're usually more subtle about when they do something bad. And so that's how you have to approach it. Now, once you get a client, and they can pay you, or they can arrange funding or whatever, we're in business at Crowell and Mooring. We're not pro bono. If you have a client that can afford these, unfortunately, very expensive undertakings, then the issue is going to be not just can you sue, but where. And this is where I think you get into the issue that we're discussing today, which is how do you get the sovereign's attention? As you've heard from other lectures and from other courses you've taken, if you've got a treaty case and it's bona fide, generally there's three ways to go about it. There's ICSID, which you've all heard about, and under the Washington Convention. That's sort of the flavor of the month. Everybody wants to have an ICSID case. But there's also the Permanent Court of Arbitration at The Hague. Ian and I actually tried a very big case there about a year and a half ago for an Italian client against the government of Lithuania. Fascinating place. If you can ever try a case at the Peace Palace at The Hague, greatest venue in the world to try a case. Giant portraits of Tsar Nicholas II, tapestries on the walls. It's a little nicer than some of the courthouses I've had to try cases in. It's even nicer than ICSID. And then third, of course, you have what are called ad hoc under the UNCITRAL rules, where a country either is not a member of the ICSID convention or for a lot of reasons I won't spend a lot of time on today, you may have some ICSID jurisdictional issues you don't want to deal with because it adds a layer of difficulty. Ad hoc UNCITRAL rules is, if you will, the lowest common denominator to still try and get into a treaty venue. And that also gives you a lot of flexibility because you're not necessarily stuck with the fees that ICSID charges or the PCA and that sort of thing. But to our theme, how do you get the sovereign's attention? Well, ICSID is popular not just because you try the cases at the World Bank in Paris or in Washington, which is very nice, by the way, and we've done both. But ICSID is critical for two very, very important reasons in terms of getting the sovereign's attention. The first is that if you are able to get through all these landmines and you're able to get an award, whatever the amount is, it's also enforceable under the same ICSID convention, the Washington Convention. Why is that important? It means it's not subject to enforcement under the New York Convention for the enforcement of arbitrations. The New York Convention, which has been on the books for decades, is the normal way you go and enforce any kind of arbitration award. It's about 150 countries all belong to it. But it's harder. You have to go to the local courts. There's more hurdles to get over. With the ICSID Convention, the Washington Convention, it's almost self-executing, almost. And you've seen several cases here in the Southern District and in the District Court in D.C. where, including our firm has been involved in a few here in the Second Circuit, where people have been attempting to enforce ICSID awards against countries like Argentina and the like. And under the ICSID Convention, it's actually easier and faster and more effective. That's why countries don't like ICSID, because if they lose, it's easier for the claimant to enforce the award. Very practical. It's not theoretical, it's practical. The second reason, just as important as to why ICSID is a nice place to go if you're trying to get the sovereign's attention, is very simple. The World Bank. Even though ICSID is not the World Bank, it's affiliated with the World Bank. And even though its tribunals are, quote, independent, it's still connected to the World Bank. And if you're dealing with a country that receives financing of very large projects through World Bank loans, and they don't want to honor an ICSID award, it's very likely the Prime Minister of the country is going to get a quiet phone call from the President of the World Bank saying, you know that bridge that you're trying to build across the, hypothetically, the Bosphorus? Well, you know, that $3 billion loan, can't find the paperwork. Oh, you're going to pay that award now. Okay, well, maybe we can find the paperwork. So there is a political element to an ICSID award to the extent that a country you're dealing with, the respondent, is the recipient of World Bank financing or aid. And so that's a very important factor to bear in mind. And it's also another reason sovereigns, or I should say the government ministers running sovereigns, don't like ICSID. Now you'd say, wait a minute, how do they not like ICSID? They make such fanfare out of negotiating and signing and putting in force all of these treaties. Sure, at the time the two governments sit down and the prime ministers or whoever, the presidents, sign and execute these treaties, they're not worried about disputes and arbitrations. They're just thinking, oh, isn't this nice? This is going to encourage a lot of investment. It's going to create jobs. A lot of money is going to come into our country from this other country. That's all they think about. They don't think about the dispute clauses. Only us lawyers worry about those things at the tail end. You know, when, as we trial lawyers say, we're here to sweep up after the elephants. We're not here to pop the champagne corks when they sign these treaties. We're here for the debris that happens when a government does something bad, and the lawyers have to come in to resolve the disputes. So that's why governments don't like ICSID. And that's why claimants do like ICSID, for those two reasons. But let's just talk for a minute about the differences between going to ICSID and going, let's say, to a place like the Permanent Court of Arbitration. The PCA, traditionally, you know, the Court of Arbitration, Permanent Court of Arbitration at The Hague is about 120 years old. No, it's 100 years old. They just celebrated their centennial. And it was started as a very interesting way to allow countries that had disputes to submit them to arbitration rather than going to war. Remember, Europe had relative peace ever since Napoleon got defeated at Waterloo. And yet there'd been regional wars, you know, the Franco-Prussians and a few other things that happened, but they had avoided a worldwide conflict. And they thought that setting up the Permanent Court of Arbitration would be an alternative to war. That was very interesting. Didn't quite work out that way. World War I and World War II kind of proved the opposite. And the PCA really lost its luster for most of this century. And it was the International Court of Justice, formerly the World Court under the League of Nations, but the ICJ, after the creation of the United Nations in 1945, that then became where governments would sue each other. And so the Peace Palace really has two, really now three, major proceedings. It also is the home of the Iran Claims Tribunal, which is a bilateral mechanism, which we have someone a little familiar with that. And it's been going on for almost 30 years and it's still not over. But why the PCA? The PCA made a comeback in the last 10, 15 years as an alternative to ICSID for treaty cases by investors. Not just because the Peace Palace is a fabulous place to try a case and The Hague is a lovely place with seafood restaurants and the ocean and all that, which it is. But more importantly, countries that didn't belong to ICSID or claimants that didn't want to go through what they perceived to be additional hurdles of ICSID jurisdictionally, the PCA was a very nice alternative. And in fact, Ian and I went through the PCA for this case between our Italian client and the government of Lithuania, which I won't get into the details, but our client had participated in a tender. Lithuania was the first country to declare independence from the Soviet Union and also became an EU member and a NATO member. They, as they say, turned to the West in a big way. But their judicial system was still untested. And unfortunately, a lot of the people running the government after the breakup, after the independent movement, were still, if you will, living in the Soviet mindset. And so when they had to privatize all of the state-owned entities, they weren't communist anymore, they couldn't win the EU if they did that, there was still a lot of corruption that came up in some of the privatizations, and our client was a victim of that. Our client won a case in the Supreme Court of Lithuania, and you would think, boy, that should be enough to get some relief on a messed up tender. But no, they didn't get any relief. So going to the PCA under a treaty was the best way our client saw politically to take the dispute out of what's called the domestic world of Lithuania, even its courts, even where they won in the Supreme Court, first and apparently only time the courts had ruled against the government in the history of Lithuania, but also as a way to provide some legitimacy to the dispute under international law. And we had a great tribunal. We had a fascinating hearing, and the award is confidential, but it worked out. And it was a way, to answer the question again, of how to get the sovereign's attention, was to take the dispute out of the Lithuanian judicial system, where it was a big scandal, by the way, and internationalize it. And that helped our client get the relief that they wanted. So that's kind of a comparison. But the difference, of course, is if you go to the PCA, an award is not enforceable under the ICSID Convention, the Washington Convention. It's not at ICSID. It's enforceable under the New York Convention, which means, yes, it's enforceable, but it's a harder row to hoe. There's more hurdles. You have to go through the domestic court systems to enforce it, where assets are located and the like. So you have to strike a balance at the very beginning of the case. Can we go to ICSID? Should we go to ICSID? How does this work with this particular country? Do they get a lot of money from the World Bank? That may lean towards going to ICSID. Do they not get a lot of money from ICSID, but we can enforce it under the New York Convention? Maybe we go to the PCA. Or maybe we even do an ad hoc under the Intra rules. Again, those are the kind of factors you have to bear in mind while you're trying to figure out how can I get the government's attention. So that's the first part. Now let me talk about some different things, sort of a different part of the conversation. How else can you get the sovereign's attention? And I mentioned to Ian before we started today, I was going to throw a few things at him. He started chuckling, and then he started laughing, and because he's worked with me on some of these cases. So I'm going to give some examples procedurally of how we've gotten the attention of the sovereign. And when I say the attention of the sovereign, I mean, the prime minister, the president, their family, that sort of thing. First, one of the things that sovereign country respondents do not like about any arbitration, particularly a treaty arbitration, is the potential that they may have to actually produce documents from their own files. They're not used to that in their legal systems. They don't have the Freedom of Information Act. They don't have just public disclosures. The government controls the information. And to prove your case on the merits is much more difficult when you cannot get documents from the other side. Well, one way, of course, to get documents is through the arbitration and the procedures, but that depends on who's on your tribunal, particularly who the president is. And just so you know, the president really runs most arbitrations. And, the wingmen, the ones appointed by the parties, they have some play. But you should always assume that it's the president who runs the proceedings, particularly on procedural issues, like documents and other things we're going to mention in a minute. Now, one thing that is new and is just now coming up that really drives sovereigns crazy is if there's any piece of the dispute, even if it's not the sovereign itself, but third parties or non-parties who have a footprint in the United States. You'd say, why? What does that have to do with an international venue? If you're at ICSID in Paris or the PCA at The Hague, or even ICSID in Washington, which technically is not in the United States. Well, if you can figure out ahead of time that anyone who has been involved with the dispute, let's say another party, another company, who has a presence in the U.S., you can attempt to seek discovery outside of the arbitration through Title 28 U.S. Code, Section 1782. Now, how many of you have ever heard of that? One. Two. 1782. This one, write down. Okay? Title 28 is the U.S. Judicial Code. U.S. Code. Section 1782 is a provision that says you can go to a U.S. court to seek documents or even testimony in a deposition to assist a foreign tribunal. Okay? Now, your lawyers, what does that mean? Well, that's what the courts have been sorting out for the past dozen or so years. At first, it was assumed just to mean foreign courts. Somebody's got a divorce case in Argentina, and the wife finds out the husband has a bank account in Miami. This is the actual case. And she has her lawyers go to Miami, and they file a 1782 action against the bank to get the bank records of the husband's account to find out that he's been dumping millions of dollars are there that he was lying about in the divorce case. Ooh, pretty clever, okay. And then you can use that in the divorce case in a judicial proceeding down in South America. But that's not really what we're talking about here today. We're talking about international arbitrations, whether they are treaty arbitrations or even international commercial arbitrations or even international judicial proceedings or administrative proceedings, like the European Union has administrative proceedings. 1782 has been used successfully by a number of parties in a number of circuits to get documents and even sworn deposition testimony to aid an international tribunal, with mixed results. Some circuits have favored it, some have not, and you have to really take a hard look, but you should all at least get some passing familiarity with Section 1782. There's been some very nice articles written about it, including one, I believe, by my colleague Birgit. I'll get a little free stuff up there, because it is a potential tool, and it drives the other side nutty, because they can't control it. So again, you want to get their attention? Think about a 1782 if there is a footprint in the U.S. And by the way, some other countries, including the UK, have not quite the 1782 proceedings, but something similar. And so you need to consult with counsel in those countries to see if there's a way to do it. And you'd be surprised, quite often in these international disputes, there's another company, there's a party, there's somebody that may have some information. And since you're fighting to get every kind of piece of paper or information you can, even a small bundle of documents can make or break a big $500 million case. So 1782 is something to really think about. We've actually litigated a few of them, and they're kind of fun. How else can we get the attention of the sovereign? Well, let's see. If you're at ICSID, and one of the reasons I like ICSID, and we've done a number of them, and I'm going to give you a few examples, is that the ICSID convention itself, I believe it's Articles 22 and 23, mandate in a dispute, in the proceedings, not only that the arbitrators are immune from judicial process, but so are the lawyers and the witnesses and the experts. Now, what does that mean? Does that mean you can kill somebody? No, of course not. But it means if you have a case that arises, let's say, in Turkey, I'm going to give you an example. We had a very notorious case a few years ago where the government of Turkey expropriated two very large hydroelectric companies. And they had earlier been owned by members of the Uzan family, one of the richest families in Turkey. The Uzans had very quietly transferred the bearer shares in those companies to a company in Cyprus, or what they call in Turkey, Greek Cyprus. And it was all done very quietly. Then there was a big problem. A couple of members of the family had to leave the country, one of whom had not been heard from for 7 years. Okay? His name was Hakan Uzan. Fast forward, we're in an ICSID proceeding in Paris. This is the famous Libanonko case versus Turkey. And Hakan Uzan, who was not the claimant, who was not the owner of Libanonko, but was a fact witness, had very important testimony to provide to the tribunal. And this is a man who had been a fugitive and not heard from in seven or 8 years. And we submitted a written witness statement to the tribunal and said, he has very important testimony to provide. And they said, fine. The other side tried to get it stricken. And I said, no, Mr. Uzan, Hakan Uzan would like to testify in person here in Paris. And the other side, popped a vein over that one, since their criminal justice system had been trying to capture him for 7 years. There were Interpol red bulletins out for him and warrants and a few other things I won't bore you with. And after fighting it out, the tribunal said, yeah, we want to hear him. We want to hear his testimony here in Paris. And Mr. Hakan Uzan did not want to disclose even where he was living, which was outside of Turkey, in an undisclosed location, as Dick Cheney used to say. And so we arranged an order of immunity under Articles 22 and 23 of the ICSID Convention, so that Turkey could not interfere with his travel to Paris, his testimony in Paris, which was over 2 days, and is returned to wherever it was he was returning, which he was not required to say, even during his testimony. And on top of that, because of this order of immunity issued by our tribunal, the French authorities, which of course France being a member of ICSID, were required to honor it. This was an order of a tribunal from ICSID. And so the French authorities gave us a piece of paper. The Ministry of Interior said, we will honor this order of immunity for Mr. Hakan Uzan. And we will not interfere with his travel. We will grant him a visa or whatever appropriate travel document is appropriate. And while he's here, and the tribunal actually said he could stay, I forget it was, a week, 7 days, 10 days, whatever it was, he will have full immunity while here in Paris. Now, this is a man who had disappeared from the face of the earth. And so when he showed up at the World Bank in Paris, there were like 80 or 100 Turkish TV cameras. And, oh, by the way, the guy is 6'8" and weighs 320 pounds. Yeah, you can look it up on YouTube, by the way. It's kind of fun. I'm getting out of the other side. I'm the guy who's not 6'8" and 320 pounds. He's the other guy. And it was very dramatic. And it drove the Turks nuts, because they were saying, under our laws, this man's a fugitive and a criminal, and we want to lock him up, and we have Interpol red bulletins, and this and that. And the tribunal said, no, we're going to hear him. And they heard him. And he testified for 2 days, and the system worked. So again, if you want to drive the other side crazy, okay, this is a way to do it. That's just an example, and I wanted to use that as an example. It's an extreme example, but it shows you that at ICSID, under the ICSID Convention, there are ways to deal with not just hostile, but adversarial, criminal, and Interpol bulletin problems that unfortunately come up in a lot of these cases. And so there are ways you can at least think about trying to solve and come up with solutions that allow you to put on your case and get testimony, regardless of what the result is, just so you can put on your case. And that's something you want to really think about in terms of what does the ICSID Convention allow, because bilateral investment treaties are silent on this issue. You're not going to find this in a bit. You're not going to find this under customary international law. You're not going to find this under the rules of the PCA or UNCITRAL. So again, which venue you select, you got a lot of things to think about that could affect how you put on your case. A few other things we can use an example, and then maybe in a couple of minutes we'll take a few questions. Yes, one of my favorites. I'll have 2 more examples. I come back to the Libanako case because you can write a whole book about it, as Ian says. Early on in the Libanako case, I was traveling to Turkey quite a bit because the fellow who owned Libanako, the Cypriot company, who was living in Istanbul and had run for prime minister and lost to the current prime minister, thus all the problems, he was under semi-house arrest, if you will, and wasn't allowed to leave the country, so I had to go there. And while I was there early in the case, I got up one morning, and there on the front page of Hurriyet, the largest newspaper in Istanbul, was a surveillance photo of me coming out of my hotel with the caption, "Turkish security services tracking Mr. Uzan's lawyer while here in Turkey." Well, that'll get your attention. It wasn't a very flattering picture either, like a Bulgarian policeman. And so I went to our tribunal. I said, what the hell's going on here? The respondent is doing surveillance of me and putting it in the newspapers. This is harassment. I have immunity. They can't do this. And the tribunal said to Turkey, yeah, what about this? And so Turkey lied. Turned out later they were lying. Oh, no. The government had nothing to do with this. It was just some reporter who mistakenly said this. Of course, big lie. Okay, fine. 6 months later, less than 6 months later, we find out from some lawyers in Istanbul that the government had obtained secret court orders in criminal cases to intercept all of my emails that were going in or out of Turkey, and all of my cell phone conversations in or out of Turkey. Now, I wasn't under investigation. My email address, and those not only of people at my firm, but some other big firms like Sidley and Austin and Baker Botts and some others which had been doing work for the Uzans in other cases, had all been intercepted. And it turned out any email I had sent to Turkey for about a 2-year period, which attached draft briefs, legal advice, things like that, were being intercepted by the Turks and shown to their local counsel in the ICSID case, despite the statement of their international counsel, who I shall not mention, that they had no idea about this. There were later documents proving the local lawyer knew all about it, in fact had orchestrated the whole thing. And the tribunal in that case, this is back in June of 2008, wrote a very lengthy decision on this. You can look it up on the ICSID website, and there's been a couple of articles written about it, about the interception of counsel's emails and phone messages and all that. And I believe it was June 2008, they wrote a very long decision about how that violates the ICSID Convention. Now, they didn't punish Turkey in the case, or as people said, they gave him a yellow card, not a red card. And for those of you who follow international football, soccer as we call it here, and it's it may be the only reported decision in existence on this issue. But again, it's an important thing to study so we can understand what can the ICSID Convention do to help protect the lawyers, privileged communications, attorney-client communications. Because if the other side is reading your draft briefs and your advice, the equality of arms, which is a principle of international law and is an essential basis of international proceedings, is grossly violated to the point where you may never get a fair hearing. And that's a very important issue to keep in mind. Last thing I'm going to mention, and then we're going to take some questions. A case that I tried just this past fall, ICSID in Paris. Again, against Turkey. Different client, Dutch client. Big case about corruption in the real estate and housing market in Turkey, which if any of you read the New York Times, you'll understand, is a bit of a conversation piece right now in Turkey, since the Prime Minister himself is wrapped up in all these allegations. The case went to hearing in October, 2-week hearing. One of the critical witnesses in the case, but who did not submit a witness statement from the other side, was the man who had run the government agency for housing that had done all the contracts and all the tenders. He had gotten promoted and was then the Minister of the Environment. He was in the cabinet. And we didn't want his testimony for his job in the cabinet. We wanted his testimony. He had literally signed every piece of paper in the dispute. He had been in every meeting with our clients. His testimony was essential for us to prove our case. And Turkey knew this. That's why they didn't put in his witness statement. And the general rule in international arbitration is if you don't put in a witness statement, you can't call them for cross-examination. That's the general rule. There's no subpoenas. But we convinced the tribunal that this man's testimony was so essential that the tribunal could not decide the merits of the case without his coming to Paris and allowing me to cross-examine him and have the tribunal ask him questions. And after a lot of fights with the other side, who of course, as you can imagine, objected quite a bit, the tribunal ordered him to appear. He did appear. He said voluntarily. And I spent half a day cross-examining him, which was a lot of fun, by the way. And fast forward, for those of you who follow these things, about a month ago, 3 ministers resigned in Turkey as part of this big corruption scandal. He was one of them. And he was the one who said, the Prime Minister told me to do all this stuff. So that was good. That's what we call good facts in a dispute. So I'm going to leave it at that as another example of, that's not in the rules. There isn't a checklist that tells you can do this. There isn't a lot of case law, although now there is some, that says you can do this. But you have to be creative in these cases. You can't just assume, well, if it's not in the rules or the terms of reference, that I can't do it. I've given you about a half a dozen examples where you potentially can. And that's how you can drive the other side crazy. So with that, maybe I'll stop there. Is that a good time? And we can have some discussion or questions or other war stories or whatever you like. Questions?
Can I maybe jump in with the first
Please.
context-setting question? In the last example, it's very clear the strategy for the case of looking outside the rules and seeing what's possible. But in some of the other examples you gave, it really was to, as you said, drive the other side crazy and
Get their attention.
get their attention. So my, I guess, context-setting question is, if it's why is it necessary or desirable to get their attention in a provocative way if it's not something that goes to the, if it's not something that's going to, or is that, strategic?
Well, you have to
How do you
decide,
decide?
is it going to help the case? A lot of times, the governments take these actions, and they're not thinking about getting sued at ICSID or the PCA. Their attitude is, we can do what we want, we are the state, and if they go to the local courts, well, too bad for them, we're just going to tell the judges how to rule, or worse. They don't think about consequences, they don't think about accountability. International investment treaty arbitration is about accountability, not only substantively, but procedurally outside of the governments, outside of the country, okay? And they can't control it much. Getting their attention is an element of the strategy. It has them take the case more seriously. It has them consider whether they should settle it or not. It has them consider if there's an award, should they fight it or not. It has the internal political consequences if this is in the newspapers a lot, and it makes them look bad. Bad for politics, bad for business, discouraging other investors from similar countries. So there's a whole list of issues. It doesn't mean that in every single case you do this, but in every single case you should consider it. It should be part of your due diligence checklist, because that is how you can best serve your client in trying to get a successful outcome of the dispute, which is what you're really trying to do. So, yes,
I have a question.
Please.
Because of this provoking.
tell me where you're from, just so I know.
Lithuania. Lithuania.
Ah,
Oh
this is the
goodness.
Buska Alita scandal, I'm
That's
sure.
what I thought. Is it a
Of
little?
course, it was a
because
scandal, right? Big scandal.
In Lithuania, like in a national way.
Oh,
because
yeah.
I didn't hear about that. This is a PCA arbitration. It's secret. I don't know. I haven't read that. So
Well,
that's
the
interesting.
award is confidential,
Yeah.
so I can't disclose it. But let's just say it worked out fine for our client. I'll just leave it at that.
Yeah.
Okay. But as you can see, that was a big scandal,
Yeah,
right?
no,
Big
and
scandal.
I was really young, but I remember that really well.
Yes, yes. See, I'm not making this up. And I didn't plant her in the audience.
Yeah, plant in Lithuania. So my question is about the provocative way you try to get attention of sovereigns, but don't you think that it's also a minus in this way that ICSID now is considered to be kind of a bad guy in this situations, and a lot of countries are trying to get out of ICSID, and new
Maybe.
countries don't want to sign up for ICSID. Australia also limiting it, and
Yeah.
don't you think that in the end it's gonna be a worse situation that we won't have any more that well disputed cases in ICSID because they won't go there?
The answer is yes and no, and I don't think it's as simple as that. Number one, it's a myth perpetuated by a lot of governments that ICSID is anti-sovereign. Most cases are decided in the favor of sovereigns, okay, by far, and most on jurisdictional grounds, so they never even get a ruling on the merits. That's just a fact.
Argentina doesn't seem.
Argentina is an exception. Argentina, if you take Argentina out of the mix, because Argentina decided to withdraw not just from ICSID, but from the world financial system. Okay, they used to issue their bonds here in New York. They stopped doing that. They can't. Argentina is a basket case today, in part for the decisions they've made for the past dozen or so years. So Argentina is really an exception. Overall, these are articles and rules that countries have negotiated for years and put into the ICSID rules and the ICSID articles. And for every crazy case I may tell you about, there's 20 or 30 or 40 where none of this happens and wouldn't happen. I'm giving you, in some ways, a bit of the extreme so that it'll stimulate you to think a little more and be creative when you're lawyers and not think by rote. But it doesn't mean that applies to every case or even most cases. I just have I have a habit of attracting these wacky cases. So, there's death squads and you don't want to know. But anyway, the short answer is ICSID's here to stay. How many cases will go to ICSID, I don't know. Are countries more careful about how they negotiate treaties? Yes. Will India and China join ICSID? I doubt it. Or Brazil. But, you can still sue them at the PCA You just have to enforce it under the New York Convention.
Do you see a new forum for this kind of arbitration, especially that all these new free trade agreements are being developed and they want their own exit, like their own arbitration, their own FTAs? Do you see
There's going to
that
be a
this
venue
can be
somewhere.
more-
So long as there are substantive protections under a treaty or a contract, there are going to be disputes resolved in a venue. Just pick the ones you like, you know. Most countries are fine with ICSID, okay? And remember, you can only withdraw prospectively. You can't, so Venezuela gets sued by, 50 companies, and Chavez, before he dies, says, I'm pulling us out of ICSID, the imperialist Yankee, blah, blah, blah. But that doesn't stop any of the cases being filed against Venezuela, and Venezuela has settled most of these cases for huge amounts of money. Why? They have no choice. You can't just say, I'm getting out of ICSID retroactively. It doesn't work that way.
20 years.
This will be your problem in 20 years, not mine. By then, I'm hoping not to be practicing, but we'll see. My daughter will be practicing. That's okay. Other questions? Yes.
I just wanted to ask.
Where are you from?
I'm from Germany.
Germany.
So you said that there's immunity protection under the ICSID Convention, which gives.
Articles 22 and 23, I
But I
believe.
think that the reason why the PCA is still in the Netherlands is because they have an agreement with the Netherlands that the Netherlands provide the same immunity to any witnesses coming to.
For travel, yes. And if you look at, and the Dutch, the Dutch are wonderful on international issues. They're very forward-thinking. They've been for 400 years. That's one of the reasons that the PCA is in The Hague. The Dutch are very good and have a protocol with the PCA about safe transit of witnesses, counsel, experts, and all that. But the protection, and I've looked at this, the protections under Dutch law that are part of the protocol with the PCA, and I'd have to go back and check, I haven't looked at it in a long time, are good, but not as broad, at least by my interpretation, as the ICSID articles, which are broader for a broader protection. You can get substantive relief, not just transit.
And also on the same point, I worked at the PCA for a while, and I also was assisted in a case where the tribunal also ordered a witness to come that was not called by either of the parties.
And it's unusual,
Yes,
right?
No, but it's not specific to ICSID.
No, it's not, and it's unusual. And my only point was to show that don't assume that just because the practice is that without a witness statement, you can't ask to cross-examine. If it is a truly critical witness, and you convince the tribunal, not that I need to cross-examine them, although that's the reason, but that the tribunal itself cannot do its job properly without assessing the credibility of this essential witness. You want the tribunal to take ownership of this issue. You want them to say, we want to see this guy. We want to eyeball him. And cross-examination is the greatest instrument for the discovery of truth ever invented. I didn't invent that, that's an old saying. And it works, and it's true. And it brings to light evidence and credibility that just cannot come up from a piece of paper. And so always think about it. Don't assume you can't do it. So another, yes?
You had mentioned two reasons why investors might want to invest your state claim, and one was to get it out of domestic courts, and the other was to convert something from a purely contractual dispute.
Mm-hmm.
Can you talk a little bit about the second? Because I think when you think about investment treaties, people focus on the first rationale. So
Yes, very much. That's a good question. Thank you. Sometimes I'll call it the foreign investor, who goes into a country, there's really two situations. They have some kind of joint venture or contract or a piece of paper under domestic law that provides for arbitration. Sometimes a domestic arbitration, sometimes an international arbitration. ICC, LCIA, SCC, whatever it is. That's sort of, been traditional. Sometimes they don't have a contractual provision. In fact, this case I just tried for a very large Rotterdam real estate development company, a company called Tulip, which is actually part of the Van Herk Group. And the award will be coming out any day. That's why keep your eye out for Tulip v. Turkey. They didn't have any arbitration clauses in any of the contracts. Bad lawyering, good lawyering, way you do business, whatever, it doesn't matter. They had treaty rights under the Netherlands-Turkey bilateral investment treaty. The bilateral investment treaty. When you go to ICSID or PCA or wherever under a treaty, the substantive analysis of the claim under a treaty is entirely different from that under a contract. Jurisdiction, merits, and very importantly, scope of damages. The scope of damages, the country or the agency or whoever may have breached the contract, and your damages would be this much under the contract. But if they breach the treaty, your damages may be this much. Because under contract law, particularly if you're bound by the local law, let's say Turkey or other civil code jurisdictions, Turkey basically follows Swiss civil code, the scope of damages are very limited. Whereas the treaty may expressly provide that if there's a breach and you can establish causation, you get the fair market value of the investment, which is very different from a breach of contract remedy, which might be lost income for a certain amount of period or interest or something like that. So quite often, this comes up in the context of where you're going to get the largest potential damages award on quantum of damages. That's a critical difference. The other part, which is very important, is that with a few very minor exceptions based on some weird treaty language, most tribunals that have addressed the issue of parallel proceedings, including in my Turkey case, the Tulip case, you can have parallel proceedings. You can be ad ICSID under a treaty, and the local entity can be in the local courts or a local commercial arbitration. And the two don't meet because they arise under different substantive law, and quite often are even different parties. There's been a few tribunals at ICSID that have stayed their cases to see what happens, but as a matter of discretion, just to see, well, maybe you'll win there, why should I bother? But there is no requirement that you have to stop the treaty case. And it may very well be the damages are going to be much bigger on the treaty side than they are under the domestic court.
Can I ask
Please, ask your
a question? I mean, it seems to me in a way that it's kind of maybe an ex post modification of the contract that's available only to the investor and not the state. Maybe it's just a comment more than a question.
That's all right. I'll react to the comment. Then the state shouldn't have negotiated this treaty. The investor didn't negotiate this treaty. The state did. The state decided under very strict constitutional and legislative formulas that it would negotiate and approve and put in force a treaty with another sovereign country. And it's mutual. It means that Turkish businesses in the Netherlands are protected and that Dutch investors in Turkey are protected. It is mutual. So to hear, as we did, a minister of the Turkish government complain how unfair this is, the response is, then tell your government not to negotiate these treaties. Nobody had a gun to your head. There's something, how many thousands of these treaties are out there now? You know, governments are presumed to know what they're doing when they put a treaty in effect, in force, with another sovereign. It is the ultimate act of a sovereign to negotiate with other sovereigns. And investment treaties, which are a modern creature, mostly, probably wouldn't be very controversial if all these crazy lawyers weren't bringing cases at places like ICSID and the PCA. That's a good thing. It means the rule of law is holding governments accountable. But most of the time, the governments win the cases. So it's a myth that it's, with a few minor exceptions.
Yeah, but that's the reason why in 2018 there's not going to be that much of bids anymore, because they want to denounce them as well.
You know, it's funny you should say that. The Lithuanians actually didn't have a problem with having a bid. Remember, they wanted to join the EU. They wanted to be in NATO. I mean, they turned their backs on the Soviet Union. They were the first ones. And then they did a 180-degree turnaround. This is the price of admission. You want to, you don't play the game, you don't make it a rules. You know, the old expression.
It's true as well.
Yes, you're being flagged. Yes, I'm sorry to go over time.
No, thank you.
But thank you all.